on the Luthuli inquest and the contributions that we can make and how we see this work in our respective spaces where we are, but also even
one is the court named 7 men who could not be located, said they could face. What is the MPA doing to trace these individuals? Number 2, the court recommended that the MP investigate the kidnapping and forced disappearance of witnesses linked to this case. What is the status of that investigation? Now that the 1967 finding has been set aside, what are the MP's next legal steps? Will there be a criminal prosecution, or is this the final process? Thank you.
We'll pause there with the questions, and I'll give my colleagues here the opportunity to comment. Please go ahead.
Thank you. To all attendees, may I start we assume, as he is concerned, that since at the time when the so-called incident took place in 1967, he would have been around 40-something years old. He was 5, reminded that being alive, but we started the inquest would have been quite minimal. But insofar as other recommendations, the inquest is not the end. As you've indicated, the investigation in respect that individual. And once the inquest is finalized and the order is made by the court, the Director of Public Prosecution seized with the matters to evaluate the evidence, the findings, and make a decision at a later stage. That decision is either that investigations should be followed in respect of identified issues of interest, and or if there is nowhere else to go, to make a finding that or a decision that the prosecution is called prosecute, which is the final closure of the matter. But there are a number of issues outstanding in respect of the Chief Albert Luthuli matter, some of which that arose during the hearing itself. And of importance and of interest is that what inquests have taught us is that, as you would have heard, I think in the Ahmed Timol matter, the first one that we had, is witnesses who could testify. Some of those witnesses do not even have statements that they would have given before they are called. But judges who are matters, they may invite whoever has information relating to the issue that the court is investigating to come forward and bring the criminal proceedings. It allows for witnesses to come forward even in instances where they may well not have given and a useful tool for achievement of justice. I hope that answers.
Yeah.
Chair, protocol, I send a few words. Have given a responsibility to see others work. Before I can deal with the questions, I wish to acknowledge some members of the multidisciplinary team. Honestly, day and night, because they have Mr. Labaskachne, who did not only provide us insight in terms of reports on the functioning and the other aspects of a locomotive of a nature that was alleged to have collided with Chief Albert Luthuli. They, Mr. Labaskachne, Mr. Van Tonder, found their way even to the Pietermaritzburg High Court to go and testify. And they testified on aspects that we wouldn't been able to get evidence on. I want to acknowledge that team, and as a person, acknowledge them for making me a better person in terms of growth in their fields of expertise. Now let me turn to the first question. I wish to point out that apartheid, as it was systematic and institutionalized crime, it was founded on not less than 148 pieces of legislation. If you look at 148 pieces of legislation, one will give our government credit because they had to define legislation. Not a legislation. You have to repeal that legislation. It was for this insurgency, quelling crowds, or more interesting was the Indemnity Acts, which ran from 1961 to 1976.